Ever wonder what happens when defendants push the limits of judicial patience? Today, we're diving into 5 wild courtroom moments where judges had to lay down the law, from suspicious Zoom beverages to outright disrespect. You won't believe some of the excuses these defendants tried to pull. First up, we're in Cannes, Ohio, for a compliance hearing involving 37-year-old Alex Cordero. He'd previously pled guilty to driving with a suspended license and expired plates, receiving a suspended jail sentence contingent on him getting a valid Ohio license. But after missing multiple deadlines, he's back before Judge Nicholas I. Roach, claiming he tried to turn himself in and was turned away. Let's see how the story holds up.
We're in Cannes, Ohio, for a hearing. 37-year-old Alex Cordero has pled guilty to driving with a suspended license and expired plates. 9 months earlier, Cordero was arrested and pled guilty to both charges. He was sentenced to 180 days in jail, with 175 suspended. And if Cordero, who'd recently moved from Arizona, became a valid driver in Ohio within 6 months, the remaining 5 days of his sentence would be suspended as well. But even after the court granted him a 3-month extension, Cordero missed the deadline. Today, he appears before Judge Nicholas I. Roach for a review of his case.
So, tell me what's going on, Mr. Cordero. Well, you didn't show up for your jail report day.
I showed up here and talked to the ladies up front. And they told me to call the following day, and they told me that you were going to explain to me everything that I was going to have to do.
That's not what was explained to me. You came here to give me a letter.
No, I was here and I asked the lady, like, do you want me to turn myself in right now? And she told me that you were going to explain it to me today. And I came to turn myself in, they told me something else.
Bring Angeline.
The judge
Here,
wants
Judge
to hear
Roach
from his
is
clerk,
immediately skeptical
Angelina
of Mr. Cordero's
Vasquez.
claims. This exchange highlights the critical role of credibility in legal proceedings. A
in
defendant's testimony is
to report
constantly
to jail
evaluated for
report on
truthfulness and
December
consistency.
3rd, and you guys
Contradictory
turned him away.
statements can severely undermine their standing with the court, impacting everything from the judge's perception during plea negotiations to their final sentencing. The judge is trying to ascertain the objective facts surrounding Mr. Cordero's noncompliance by bringing in his clerk, Angelina Vasquez, to corroborate or refute his story.
The day you were supposed to report to jail, and the clerk of courts turned you away. Now you're telling her that you actually gave something in writing to her.
Yes.
So tell me what's the truth. Did you show up and turn yourself in, or did you come here and deliver a letter?
I showed up to do both.
Vasquez, did he tell you he's turning himself in?
Yeah.
I don't remember that.
Why would I show up to court and not turn myself in?
Because you turn yourself into the jail. You don't turn yourself into the court, and the only reason you come to court is to ask for another extension, which is what your letter essentially does.
Thank you, Ms. Vasquez. You're excused.
Thank you, sir.
You know, when people call my clerks out, I'll bring them in.
That's what happened.
Mr. Cordero, you're full of it. Absolutely full of it. I've been doing this thing for 36 years. Think I'm stupid? Think I was born yesterday? You certainly are acting like it. And yet, I'm going to give you another break.
Judge Roach's blunt assessment of "you're full of it" is a clear indication that he finds Mr. Cordero's explanation entirely fabricated. While not a direct citation of a statute, this moment speaks to the inherent authority of a judge to assess witness testimony and make findings of fact. Judges have vast experience recognizing evasive or untruthful statements, and attempting to mislead the court can, in some cases, even lead to charges of perjury or contempt of court. However, despite his obvious frustration, the judge still extends a significant amount of leniency, offering Cordero one last chance to rectify his situation, demonstrating that even exasperated judges aim for rehabilitation when possible.
Okay, I will recall the jail commitment, but you'll have until January 13th to pay it all in full. If you're not valid by then, just bring your clothes. You're going to spend 5 days in jail.
2 weeks later, Cordero showed proof of a valid Ohio driver's license and paid his remaining court costs. He did not have to go to jail, and the case is now closed. Next, we're in Detroit, Michigan for a no-show hearing. 38-year-old Deontay Lockett has been charged with having an open container of alcohol in a vehicle. 3 years earlier, Lockett was riding in the passenger seat of a car that was pulled over by a state trooper. He was cited for the open container and ordered to appear in court. But when Lockett was a no-show, a warrant was issued for his arrest. Today, he appears remotely before Judge Sean Perkins. He's represented by attorney Dennis Whitey.
Deontay? Mr. Deontay! What's your full name, Deontay? Mr. Deontay!
Lockett doesn't seem to hear the judge. He does, however, appear to have brought a beverage to the hearing.
What do you have in the bag? What do you have in the bag, sir? Mr. Deontay? Mr. White? You need to call him because I'm pretty sure that was some alcohol that he had in that bag.
Sounds good.
Next, we're in Detroit, Michigan, with Deontay Lockett, who's been charged with an open container violation. This clip is a prime example of failing to adhere to court decorum, even in a virtual setting. While there isn't a federal statute specifically prohibiting drinking during a Zoom court appearance, courts operate under strict rules of professional conduct and judicial ethics. Many states, like Michigan, expect participants to treat the court with respect. Showing up, especially with a visible alcoholic beverage, not only disrespects the court, but could potentially lead to contempt of court charges. Given the original charge, the judge's immediate suspicion is entirely justified, and it's a terrible look for Mr. Lockett right out of the gate.
Let me get a hold of him, Judge.
What I know about that is he's got liquor and alcohol in that bag.
I observed.
10 minutes later, Judge Perkins recalls the case.
Mr. Lockett,
Hey, how you doing?
how are you?
I'm fine.
Where are you?
At a car wash, I'm at work. It's bad service here.
Do they allow you to drink at work?
No.
You're gonna have to go to a quieter place.
The defendant finds a new location.
Hello.
You're gonna have to go to a quieter place.
I walked away. You don't hear nothing. That's why I walked away.
All right.
Your Honor, today's the day and time set for trial in this matter. The trooper does not appear to have appeared today, and therefore we would move to dismiss without prejudice.
You got everything. Don't say that. You got everything. Right in the same side. Oh,
I still hear all the background noise. You need to start showing some more respect, sir.
I'm saying I'm at the car wash. I gotta be
know.
closer there to get the Wi-Fi. Like that's what I'm saying. You mean more respect?
More respect, you're sitting there drinking while you're in court on the Zoom.
In the end, the judge decides to give Lockett a break.
Case dismissed.
Judge Perkins' admonishment for more respect highlights a universal expectation in any court, virtual or in person. The Michigan Rules of Court, particularly Michigan Court Rule 8.101, generally outline the decorum and conduct expected in judicial proceedings. Despite Mr. Lockett's apparent lack of respect and potentially being intoxicated, the case is dismissed because the state trooper, the prosecuting witness, failed to appear. This is a common occurrence in criminal procedure. If the prosecution cannot present its witnesses, especially the arresting officer, the court may be compelled to dismiss the case for lack of evidence, often without prejudice, meaning the state could refile, but rarely does.
Have a very good day. Best of luck to you.
All right, thank you.
Have a good holiday weekend.
All right, thank you.
You already started.
Yeah.
Log off now, Mr. Lockett. Log off.
All right, thank you.
Since the state trooper failed to appear that day, Lockett's case was dismissed. The court never confirmed the contents of Lockett's bag. Next, we head to Houston, Texas for a plea hearing. 32-year-old Delroy Wakefield has been charged with possession of marijuana. 7 months earlier, Wakefield, whose criminal record includes convictions for armed robbery and aggravated assault, was arrested for carrying 2 to 4 ounces of marijuana. He was released on a $100 bond. And today, Wakefield appears before Judge David Fleischer, who, since it's Halloween, is sporting a Beetlejuice-style jacket.
Mr. Wakefield, you're charged with possession of marijuana. You're facing up to a year in jail and or a $4,000 fine due to the amount. You've worked out an agreement. They're offering you 30 days in jail credit for the 4 days that you've already done. Understand that this charge will go on your record. It'll be there for the rest of your life. Do you understand?
In Houston, Texas, Delroy Wakefield faces a plea hearing for possession of marijuana. In Texas, possession of 2 to 4 ounces of marijuana is typically a Class B misdemeanor under Texas Health and Safety Code Section 481.121, which carries a potential punishment of up to 180 days in county jail and or a fine of up to $2,000. The judge's mention of up to a year in jail and or a $4,000 fine might indicate prior convictions, elevating the possible penalty, or a slightly different interpretation of the amount, pushing it into a higher misdemeanor classification. The offer of 30 days is a common plea bargain, where a defendant agrees to a guilty plea for a specific, often reduced sentence, avoiding the uncertainty of a trial.
I mean, do you have a job? What do you do in life? It's not funny. You're using all kinds of dope. You've got no job. What the hell are you going to be doing in 30 years from today, man? You're going to end up on the street, jobless, prospectless, ain't got no money. Where are you going in life, man? It's not a good way to be in life. I know that you like to have fun. I know that you like to party, but you got to think about your future. And if you got no job, you ain't got no money, you're on the street begging, either that, or you're going to be slinging. You get caught up in that, you're either dead or with a 40-year sentence. Have you ever had a full-time job?
Yes.
Doing what?
I was a pipe fitter.
You were a pipe fitter. For real. Dude, pipe fitting, if you get a trade like that, you can kill it, man. What you do now, it sucks. Sucks. You have to do something in your life, Mr. Wakefield, because if you don't, you're going to end up in jail with a lengthy sentence or on the street. You work hard now, so you set yourself up for the future, so you can have vacations. You can buy nice cars the legitimate way. What you're doing now, it sucks. It's not a good way to go through life, man. The reason I'm telling you this, Mr. Wakefield, is because your demeanor and the way you act when you come in here, you think it's a joke. And what I'm trying to tell you is that your future should mean something.
Before accepting the plea, Judge Fleischer has a final message for the defendant.
Judge Fleischer's impassioned speech goes beyond simply stating the law. He's exercising his judicial discretion to counsel a defendant. While a judge's primary role is to apply the law, many also see it as their duty to impact lives positively, especially with repeat offenders or young defendants. This isn't about a specific legal code, but about the broader goals of the justice system, including rehabilitation and deterring future criminal behavior. His tough love approach is designed to shake Mr. Wakefield out of what the judge perceives as apathy or a lack of seriousness about his predicament, hoping to spur him towards a more productive path.
We have enough people in custody as it is. Your life is hard enough as it is. It doesn't get easier the older you get. It gets harder. You get fatter. You get uglier. You lose hair. The older you get, the more unemployable you get. So if you don't set yourself up now, you're gonna be nothing in 20 years. Do something, Mr. Wakefield. How do you plead, guilty or not guilty? I will find you guilty, sentence you to the agreement. One more thing. If you come back, it's not gonna go well. Good luck, Mr. Wakefield.
Wakefield was taken into custody and served 26 days in the county jail. The case is now closed. Next, we head to Houston, Texas for a bond violation hearing. 25-year-old Genesis McCullum has been charged with failure to identify oneself to a peace officer. 2 months earlier, police say McCullum crashed his car into a utility pole and was found by a police officer asleep in the driver's seat. When McCullum refused to give his name to the officer, he was arrested. A blood test later determined that his BAC was .075, below the legal limit. McCullum, who already had an active warrant for failing to appear in court over an unrelated weapons charge, was released on $5,000 bond with several conditions, including that he wear a GPS ankle monitor and abstain from drugs and alcohol. But when pretrial services was unable to locate him through his GPS tether, and McCullum was unresponsive to phone calls from them, both violations of his bond, he was ordered back into court. Today, he appears holding his infant son before Judge David Fleischer to hear if his bond will be revoked. He's represented by attorney Hunter Hoagland.
I'm not happy with you. You have a monitor on your ankle. It's been dead. Is it still dead now?
I keep my charger with me. I keep it with me wherever I go. But my ankle monitor is messed up. They said it's not functioning. So sometimes.
Felicia, tell me what's going on with Mr. McCullum.
In our next case, Genesis McCullum is in Houston, Texas, for a bond violation hearing. When a defendant is released on bond, conditions are often attached to ensure public safety and court appearance, as seen here under Texas Code of Criminal Procedure Article 17.15. These conditions can include wearing a GPS ankle monitor and abstaining from drugs and alcohol. Mr. McCullum's dead monitor and unresponsiveness are direct breaches of these court-ordered conditions. The judge's immediate inquiry to pretrial services shows the seriousness with which these violations are treated, as they directly challenge the court's authority and the integrity of the bond system.
No.
The judge checks in with Felicia Childs from Pretrial Services, who's off camera.
So I believe on the 2nd, we lost service until the 5th, and then it came back on, and then on the 8th, his last court date, it went off again for about 6 hours. We send messages out to tell them to have the device inspected as well, and if they have any issues with that, they're instructed very thoroughly to let us know.
Judge, I would ask if the court would check the device and if there is something wrong for them to put him.
I'm putting him in jail. I don't know what you're gonna do with this kid, man.
I haven't done anything wrong, sir. I promise.
But you have done something wrong. You've repeatedly done something wrong.
I put my ankle monitor, like, I didn't know it was dead. I promise you, I go to school every day.
The reality is, you tell me something, but the machine tells me something different.
Can we get it inspected and get it checked out, please? Because I know it's not.
That is what you're supposed to do at the first instance that there is a problem.
At this point, Judge Fleischer seems frustrated with McCullum's responses.
Here's what we're going to do. I'm now sending you for a drug and alcohol test. I want to know what, if anything, is in your system.
Sir.
Do you understand?
Sir.
You were to come back tomorrow. Don't come back here with the baby. Because if you're here and I put you in custody for one reason or the other, I will call CPS. Do you understand?
Sir.
And if you continue to piss on my leg and tell me it's raining, there will be issues. Do you understand? You will be back here tomorrow.
The next day, McCullum tested positive for THC. But about a month later, according to court records, the state decided to drop that case and focus on his weapons charge.
Judge Fleischer's colorful metaphor, "piss on my leg and tell me it's raining," is a clear warning against dishonesty and disrespect, indicating his absolute zero tolerance for Mr. McCollum's excuses. This directly relates to the concept of contempt of court, which refers to any act that obstructs justice or tends to bring the court into disrepute. Continuously lying or being evasive can escalate judicial frustration and lead to more severe consequences, including bond revocation and being held in custody. The subsequent positive THC test further solidifies the judge's suspicion that McCollum was not adhering to his bond conditions, illustrating why judges often rely on objective evidence, like drug tests, over a defendant's self-serving statements.
He remains free on bond and has yet to enter a plea. If found guilty, McCollum's looking at a potential maximum sentence of a year in prison plus a $4,000 fine. Next, we go to Detroit, Michigan for a pretrial hearing. 21-year-old Jeremiah Townsend has been charged with interfering with a government employee performing their duty. 10 months earlier, police say Townsend ignored an order from an officer to step back from a police cruiser during an investigation. He was arrested, released on a personal recognizance bond, and has pled not guilty. Today, he appears remotely before Judge Marlena Taylor to discuss next steps in the case. Townsend's represented by public defender Dennis Whitey.
Hey, excuse me. I was trying to get placed back to the breakout room.
What are you trying to get placed back in the breakout room for?
I was trying to speak to my attorney.
You still need to talk to him for a moment?
Yeah, he had just came in.
Yeah, I did, Mr. Townsend. I don't have discovery yet. We're going to get that, and then I'm going to call you later today, okay?
All right, cool. Yep.
Yeah, we'll talk about it. For sure.
No problem.
We're ready, Judge, whenever you are.
Okay.
As Judge Taylor reviews some paperwork, Townsend can be seen moving behind the couch and then returning with what appears to be smoking paraphernalia. The judge is not happy.
Mr. Townsend, I know you are not about to fix and smoke online, really?
Hey, can you hear me? I got this little button. I'm trying to work it out to Bluetooth, but no, I'm okay.
Mr. Townsend! Mr. Townsend!
Yes, ma'am.
I can see you. I can see what you're doing.
Finally, we head to Detroit, Michigan for Jeremiah Townsend's pretrial hearing. This scene is yet another stark reminder of the importance of court decorum, even in virtual settings. While there may not be a specific statute against smoking during a Zoom court hearing, general rules of conduct and respect for the court, outlined in things like Michigan Court Rule 8.101, absolutely apply. Such behavior, especially if it involves smoking paraphernalia, can be interpreted as contempt of court, a punishable offense. The judge's immediate and visible displeasure clearly shows that Mr. Townsend's actions are highly inappropriate and will undoubtedly prejudice the court against him, affecting how his case is viewed and potentially even future rulings.
Sorry about that.
Do you think that was good behavior for being in court in the morning? It's 9:41. It's 9:41 in the morning, for real?
Yeah. Wake and bake.
Ooh.
It's
Mr.
nothing.
Whitey, I know that you haven't had a lot of interactions with him. So when you have interactions with him, just remind him what the court is about and how to act in the court. They are testing my patience this morning, and I'm not going to fail this test. I promise myself. Okay.
Your Honor, I just was appointed 2 days ago to this case. I've put a discovery request in, spoke to the prosecutor as well. If there's a pretrial date, we could come back in the next few weeks, maybe to resolve the matter. That'd be appreciated.
Do you want to do it in person or via Zoom?
Let's do it in person, the bench trial.
Okay.
And then if we resolve it,
I really
great.
would like him to come down here, so I agree with that. Because maybe his conduct will be different if he were to come to court. Mr. Townsend, am I laughing right now?
Nah.
I am disappointed. Like, that's not what you want to see, first of all. It's not even noon. So that lets me know what you're doing with yourself right now, or potentially be doing with yourself.
Definitely.
And then,
right.
You said what?
No, I was just saying definitely.
Mr. Townsend, that is not what you want to give people an image of, especially the judge.
Definitely.
Okay. Okay, I just need you to realize it, okay? So like I said, your attorney's gonna talk to you. Don't do that. Some people will lock you up. Okay?
Okay.
2 months later, Townsend failed to appear for his bench trial, and the judge issued a warrant for his arrest. His case is pending, and if found guilty, he could be facing a maximum sentence of 2 years in prison plus a $2,000 fine.
So what happened with our defendants? Alex Cordero ultimately showed proof of a valid Ohio driver's license and paid his court costs, avoiding jail time. His case is now closed. Deontay Lockett's open container case was dismissed because the state trooper failed to appear that day. The court never officially confirmed the contents of his bag. Delroy Wakefield accepted his plea deal, serving 26 days in county jail for marijuana possession. His case is also closed. For Genesis McCollum, after testing positive for THC, the state decided to drop the failure to identify case and is now focusing on his unrelated weapons charge. He remains free on bond and has not yet entered a plea on that matter. Lastly, Jeremiah Townsend failed to appear for his bench trial 2 months later, and a warrant was issued for his arrest. His case remains pending, and if found guilty, he could face a maximum sentence of 2 years in prison, plus a $2,000 fine. That's it for today's look at courtroom drama. Remember to always show respect for the court, whether you're in person or on Zoom.